Hi, my name is Siri. I am not an attorney, but my principles are. I am just a robot. Welcome to SIRI'S Law. And today, I will discuss Chapter 1, the general provisions of the law on obligation. In this video, I will discuss the Civil Code provisions on obligations from Article 1156 to 1162. But before I begin, allow me to say thank you for watching. We will be uploading more videos like this, so make sure to subscribe for more. Let us begin. The Law on Obligations and Contracts. Chapter 1. General Provisions. Article 1156 provides, an obligation is a juridical necessity to give, to do, or not to do. The term obligation is derived from the Latin word obligatio, which means tying or binding. It is a tie or bond recognized by law, by virtue of which one is bound in favor of another to render something, and this may consist in giving a thing, doing a certain act, or not doing a certain act. Article 1156 is the Civil Code definition of obligation in its passive aspect, because it merely stresses the duty of the debtor or obligor. Stated otherwise, it speaks of the obligation of the one who has the duty of giving, doing, or not doing. Obligation is a juridical necessity because in case of non-compliance, the courts of justice may be called upon by the aggrieved party to enforce its fulfillment. In other words, the debtor must comply with his obligations whether he likes it or not. Otherwise, his failure to comply will render him liable and a court action may be brought against him. Think about this. If obligations were not made enforceable or obligatory, then people can disregard them with impunity. Moreover, obligations which give to the creditor a right under the law to enforce their performance in courts of justice are known as civil obligations. They are to be distinguished from natural obligations, which are not being based on positive law, but on equity. Natural obligations do not grant a right of action to enforce performance. Although in case of voluntary fulfillment by the debtor, the latter may not recover what he has delivered or rendered. Let us now enumerate and discuss the essential requisites or elements of an obligation. The following are the four essential elements of an obligation. 1. A passive subject, called debtor or obligor, is the person who is bound to the fulfillment of the obligation. He who has a duty. 2. An active subject, called creditor or obligee, is the person who is entitled to demand the fulfillment of the obligation. He who has a right. 3. Object or prestation, also known as the subject matter of the obligation. Prestation is the conduct required to be observed by the debtor. It may consist in giving, doing, or not doing. We say that without prestation, there is nothing to perform. 4. A juridical or legal tie, also called efficient cause, is that which binds or connects the parties to the obligation. The tie in an obligation can easily be determined by knowing the source of the obligation. Let us have an example of obligation and learn to determine the essential elements. In a construction contract, Debbie bound herself to build a house for Chris for 1 million pesos. In this example, Debbie is the passive subject, Chris is the active subject. The construction of the house is the object or prestation, and the construction contract, which is the source of the obligation, is called the juridical tie. Suppose Debbie had already constructed the house, and it was the agreement that Krista would pay Debbie after the construction is finished. Debbie then becomes the active subject and Krista now the passive subject. Next, let us talk about forms of obligations. When we speak of forms of obligation, we refer to the manner in which an obligation is manifested, either oral, written, or partly oral, and partly written. An obligation may be oral, or in writing, or partly oral, and partly in writing. An obligation, as a general rule, is valid in any of these forms. As a general rule, the law does not require any form in obligations arising from contracts for their validity or binding force. On the other hand, obligations under Article 1157 arising from other sources, except from contracts, do not have any form at all. Now, let us try to distinguish or differentiate the term obligation, right, and wrong. Obligation is the act or performance which the law will enforce. On the other hand, a right is the power which a person has under the law to demand from another any prestation, while a wrong is an act or omission which constitutes cause of action. It is an act or omission of one party in violation of the legal right of another. In law, the term injury is also used to refer to the wrongful violation of the legal right of another. Remember that an obligation of a person cannot exist without a corresponding right in favor of another, and vice versa. A wrong or cause of action only arises at the moment a right has been transgressed or violated. Let us revisit our first example, under a building contract between Debbie and Krista. Debbie bound herself in a construction contract to build a house for Krista for 1 million pesos. In this example, Krista has the legal right to have his house constructed by Debbie. Debbie, on the other hand, has the correlative legal obligation to build the house under their construction contract. Now let's take up the kinds of obligations according to subject matter. As to subject matter, obligation may either be real or personal. Real obligation or obligation to give is when the subject matter is to deliver a thing, or simply an obligation to deliver. For example, Debbie, a seller, binds himself to deliver a piano to Krista, the buyer. In this example, Debbie has a real obligation, which is to deliver a piano. On the other hand, personal obligation is when the subject matter is an act to be done or not to be done, or simply, the obligation to do or not to do. There are two kinds of personal obligation, namely, positive personal obligation and negative personal obligation. Positive personal obligation is an obligation to render service. For example, Debbie binds himself to construct the house of Krista. On the other hand, negative personal obligation is an obligation not to do. Moreover, negative personal obligation naturally includes obligations not to give. For example, Debbie obliges herself not to build a fence on a certain portion of his lot in favor of Krista, who is entitled to a right of way over the said lot. Now, let us move to Article 1157. Sources of obligations. Obligations arise from 1. Law. 2. Contracts. 3. Quasi-contracts. 4. Acts or omissions punished by law. And 5. Quasi-delicts. Okay, let us discuss these sources one by one. First, law. It is when the obligation is imposed by law itself. For example, obligation to pay taxes, obligation to support one's family. These are examples of obligations imposed by law. Second source of obligation is contract. It is when the obligation arises from the agreement or stipulation of the parties. For example, the obligation to repay a loan or indebtedness by virtue of an agreement, or obligation to deliver in a contract of sale. The third source of obligation is quasi-contracts. It is when the obligation arises from lawful, voluntary, and unilateral acts which are enforceable, to the end that no one shall be unjustly enriched or benefited at the expense of another. For example, if a person received payment by mistake we mean that such payment is not yet due to him, or when he has no right to receive such payment. If a person received payment by mistake, an obligation to return the money will arise. This obligation to return is based or emanates from the provisions on quasi-delict, particularly solutio indebiti. Fourth source of obligations is crime, or acts or omissions punished by law. It is when obligations arise from civil liability as consequence of a criminal offense. For example, the obligation of a thief to return the car he has stolen. Another example. In the case of murder or homicide, the duty of a killer or the accused to indemnify the heirs of his victim. The fifth source of obligation is quasi-delicts or torts. It is when obligations arise from damage caused to another, through an act or omission, there being fault or negligence, but no contractual relation exists between parties. For example, the obligation of the head of a family that lives in a building or part thereof to answer for damages caused by things thrown or falling from the said building. Another example is the obligation of the possessor of an animal to pay for the damage which the animals may have caused. I would just like to point out that if we examine the 5 sources of obligation that we just discussed, we could conclude that there are only 2 sources of obligations, namely, law and contracts. This is because obligations arising from quasi-contracts, delicts, and quasi-delicts are really imposed by law. Now let's proceed to Article 1158, which provides that obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable, and shall be regulated by the precepts of the law which establishes them. And as to what has not been foreseen by the provisions of this book, Article 1158 refers to legal obligations or obligations arising from law. They are not presumed because they are considered a burden upon the obligor. To be demandable, the obligation must be clearly set forth in the law. Under Article 1158, special laws refer to other laws not contained in the Civil Code. Examples of such laws are tax law, corporation law, negotiable instruments law, insurance code, revised penal code, labor code, and etc. Next is Article 1159, which states that obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. This article speaks of contractual obligations, or obligations arising from contracts or voluntary agreements. Under Article 1305 of the Civil Code, a contract is defined as the meeting of the minds between 2 persons, whereby one binds himself, with respect to the other, to give something, or to render some service. Obligations arising from contracts have the force of law between the contracting parties, meaning they have the same binding effect as obligations imposed by laws. This does not mean, however, that contract is superior to the law. To be a source of enforceable obligation, a contract must be valid. And a contract cannot be valid if it is against the law. If all the essential requisites are present, a contract is valid if it is not contrary to law, morals, good customs, public order, and public policy. Stated otherwise, a contract is void if it is contrary to law, morals, good customs, public order, or public policy. Simply put, a contract must not be contrary to law. In the eyes of the law, a void contract does not exist. Consequently, no obligations will arise. Moreover, there are instances that a contract may be valid but cannot be enforced. This is true in the case of unenforceable contracts. In the case of an unenforceable contract, the parties thereto cannot go to court to enforce the contract. Now let us talk about breach or violation of contract. When is a contract considered breached? A contract may be breached or violated by a party in whole or in part. A breach of contract takes place when a party fails or refuses to comply his obligation without legal reason or justification. Now, if a person or party to a contract performs his obligation in a contract, he must do so with sincerity and honesty. We call this compliance in good faith. Compliance in good faith means compliance or performance in accordance with the stipulations or terms of the contract or agreement. A party in the performance of his obligation must not take advantage over the other party. Non-compliance by a party with his legitimate obligations after receiving the benefits of a contract would constitute unjust enrichment on his part. For example, if Sam agrees to sell his house to Ben, and Ben agrees to buy the house of Sam, voluntarily and willingly, then they are bound by the terms of their contract. And neither party may, upon his own will, and without any justifiable reason, withdraw from the contract, or escape from his obligations thereunder. The stipulations in the contract, entered into by Sam and Ben, is the law between them. They must comply with it, in good faith. Let us have another example. Charlie hired Cardo to kill 30 for a consideration amounting to 1 million pesos. In this example, the contract between Charlie and Cardo is void and non-existent, because killing a person is contrary to law. Consequently, in this case, Charlie has no obligation to comply with his agreements. In fact, even if Cardo successfully killed 30, Charlie cannot be compelled to pay the 1 million pesos. However, Charlie and Cardo can be held criminally liable for murder or homicide. Moving on, let us take up Article 1160, which provides, obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. Article 1160 speaks of obligations arising from quasi-contracts. Quasi-contracts are implied by law. Quasi-contract is defined as juridical relation, resulting from lawful, voluntary and unilateral acts, by virtue of which the parties become bound to each other, to the end that no one will be unjustly enriched or benefited at the expense of another. When we speak of a quasi-contract, it is not properly a contract at all. In contract, there is a meeting of the minds or consent. In contract, the parties deliberately entered into a formal agreement. On the other hand, in quasi-contract, there is no actual consent, but consent is supplied by fiction of law. In other words, the law considers the parties as having entered into a contract, although they have not actually done so. The obligation arises regardless of the intention of the parties. The purpose of this is to prevent injustice, or the unjust enrichment of a person at the expense of another. Now let us discuss the kinds of quasi-contracts. There are two primary kinds of quasi-contracts. First is negotiarum gestio. Negotiarum gestio is the voluntary management of the property or affairs of another, without his knowledge or consent. For example, Rita went to Australia with her family without leaving somebody to look after her house in Manila. While in Australia, a huge fire broke out near the house of Rita. Through the effort of John, a neighbor of Rita, the house of Rita was saved from being burned. However, John incurred expenses in saving the house of Rita. In this example, although Rita did not actually give her consent to the act of John in saving her house, Rita has the obligation to reimburse John for his expenses. This is based on the principle of quasi-contract known as negotiarum gestio. The second kind of quasi-contract is called solutio in debiti. Solutio in debiti is the juridical relation, which is created when something is received when there is no right to demand it, and it was unduly delivered through mistake. The essential requisites of solutio in debiti are the following. 1. There is no right to receive the thing delivered, and 2. The thing was delivered by mistake. For example, Daisy owes Kathy 1 million pesos. If Daisy paid Karen the 1 million pesos, believing that Karen was authorized to receive payment for Kathy, when in fact she is not authorized, the obligation to return on the part of Karen arises. Suppose in our example, Daisy instead paid Kathy 1,500,000 pesos by mistake. Kathy has the obligation to return the excess amount of 500,000 pesos. Next is Article 1161, which states that civil obligations arising from criminal offenses shall be governed by the penal laws, subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2. preliminary title on human relations and of Title 18 of this book regulating damages. This article deals with civil liability for damages arising from crimes or delicts. Oftentimes, the commission of a crime causes not only moral evil, but also material damage. From this principle, the rule has been established that every person criminally liable for an act or omission is also civilly liable for damages. However, in crimes which cause no material damage, like for example, in contempt of court, gambling, violations of traffic regulations, there is no civil liability to be enforced. But a person not criminally responsible may still be liable civilly, such as failure to pay a contractual debt, or in case of causing damage to another's property without malicious or criminal intent or negligence. The extent of the civil liability for damages arising from crimes is governed by the revised Penal Code and the Civil Code. Civil liability may include 1. Restitution, 2. Reparation for the damage caused, and 3. Indemnification for consequential damages. For example, Robin stole the car of Prince. If Robin is convicted, the court will order Robin 1. To return the car, or to pay its value if it was lost or destroyed. 2. To pay for any damage caused to the car. And 3. To pay such other damages suffered by Prince as a consequence of the crime. Next is Article 1162, which provides, obligations derived from quasi delicts shall be governed by the provisions of Chapter 2, Title 17 of this book, and by special laws. This provision speaks of obligations arising from quasi delicts or torts. This is the fifth and last source of obligation enumerated in Article 1157. Quasi delict is an act or omission by a person which causes damage to another in his person, property, or rights, giving rise to an obligation to pay for the damage done, there being fault or negligence, but there is no pre-existing contractual relations between the parties. The person who is guilty of quasi delict or tort is called the tortfeasor. The elements of quasi delicts are the following. 1. There must be an act or omission. 2. There must be fault or negligence. 3. There must be damage caused. 4. There must be a direct relation or connection of cause and effect between the act or omission and the damage. And 5. There must be no pre-existing contractual relation between the parties. For example, while playing soccer with his classmates, Arnold broke the window glass of Carla, his neighbor. The accident would not have happened had they played a little farther from the house of Carla. In this case, Arnold is under the obligation to pay the damage caused to Carla by his act, although there is no pre-existing contractual relation between Arnold and Carla. This is because Arnold is guilty of fault or negligence. Okay, let us now distinguish a crime from quasi delict. 1. In crime, there is criminal or malicious intent, while in quasi delict, there is only negligence. 2. In crime, the purpose of the law is punishment of guilty party, while in quasi delict, the purpose of the law is indemnification of the offended party. 3. Crime affects state or public interest, while quasi delict concerns private interest of the parties. 4. In crime, there are generally two liabilities, criminal and civil, while in quasi delict, there is only civil liability. 5. Criminal liability cannot be compromised or settled by the parties themselves, while the liability for quasi delict can be compromised, just like any other civil liability. And finally, 6. In crime, the guilt of the accused must be proved beyond reasonable doubt, while in quasi delict, the fault or negligence of the defendant need only be proved by preponderance of evidence, or that which is superior, or greater weight of evidence. Alright, that's all for the general provision of the law on obligations and contracts. If you enjoy this video, please go ahead and leave a like, and subscribe to our channel for more. Thanks.